Hello guys, let's begin. Previous video we saw till preamble. Now let's start from here. The preamble reaffirms that people of India have adopted, enacted, and given to themselves the constitution. As we know, it's written in the preamble last lines that on this 26th day of November 1949 do hereby adopt. We the people of India is given in the starting of preamble, and in the last it's written that we hereby adopt, enact, and give to ourselves this constitution. That means, as per the preamble, the citizens of the nation have adopted, enacted the constitution. Supreme Court in Charan Lal Sahu versus Union of India, popularly known as Bhopal Gas Leak Tragedy case, held that sovereign denotes that India is not subject to any external authority, and India as a state has power to legislate on any subject in conformity with constitutional limitations. So constitution is the supreme law making body, or it's the supreme authority that everybody is restricted to. Not only the central government, but everybody, each and every person is limited or restricted under the constitution umbrella. So in the Supreme Court case of Charan Lal Sahu versus Union of India, it was said that India is a sovereign country, which means that India is not bound to any external authority, any external interference of any sort, and it can take decisions on its personal matters, on its internal matters on its own, without the interference or without the intervention of any other nation of the world. Like it happened in the CAA NRC matter also, various international organizations or various countries said that it is wrong, this legislation of central government is wrong, you should take it back, you should revoke it. But India, on all sort of international levels, it kept on saying India is a sovereign nation, it's an internal matter of the country, and so nobody can interfere with it. No nation can tell or guide India how it has to deal with its internal matters. It's totally upon the wish of the Indian government only. So that is the benefit of sovereignty, and India can legislate on any internal matter of its own with conformity, just that it has to be restricted as per the constitution. Preamble states that India's governing system is based on republican and democratic principles. So republican means head of the government is, or head of the country is elected, and democratic, we know democracy what it is. In S.R. Bommai versus Union of India, Supreme Court held that democratic signifies that India has a responsible parliamentary form of government which is accountable to the elected legislature. As we know what democracy means, that elections will be held, and wherein the citizens of the nation will themselves elect their representatives, and that will form the government of the nation, and that government is responsible for the common people. Means whatever they are working or whatever decisions they are taking, that should be in the welfare of the general public, that should be for the good of the people, because whatever action or whatever legislation they are taking up, they have to answer it to the general public, that why it had happened. That means they are responsible, they are answerable to the general public, and if they are doing anything which goes against the interest or welfare of the nation, then it may happen that in the next elections they won't be elected, right? So they have this fear, and that's why they try to work for the good of the people, or whatever the interest of the general public at that particular instance would be. Republic denotes that head of the state is an elected person and not a hereditary monarch. Any Indian without any discrimination to caste, creed, religion can contest for presidential elections and can occupy the office provided he fulfills the eligibility conditions as provided by constitution. I think I have told you in the first or second lecture of this chapter only that what would be the qualifications, what body will be there for this particular task, what would be the qualification for the head of the person, who will be the head, how many members will work under the head. All those things are also very clearly mentioned in our constitution, and on the basis of that only we say that anybody regardless of any sort of discrimination. See, there is no sort of discrimination which is done. Anybody can contest for any level of election, and he can be elected also. It may happen that if he get the majority of votes of the people living thereby, he may win the elections also, or whatever the case may be. But any person can run for any level election in the country. And even in the presidential election, it's not that only the rich people or the high status people can stand for the election. No, it's nothing like that. Even for the presidential election, any person can run it. The preamble seeks to achieve for all citizens social, economic, and political justice, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, fraternity, unity, and integrity of the nation. This is all what is mentioned in the preamble, which means that its main objectives are that each and every citizen of India is considered equal in terms of opportunities that they are getting, and in the form of status. Means there should be no discrimination on the basis of caste, creed, sex, religion, or whatsoever. There must be freedom of thought. What they must be free to think whatever they want, to express what their beliefs or thinkings are, and to worship and to have faith on whatever they like for. And also, a fraternity means they have a kind of friendship or bhaichara sort of thing, which we say in Hindi. Sorry. And there is unity and integrity of the nation also maintained thereby. Preamble and constitutional provisions aim to secure to its citizens equality of status and equality of opportunity in state affairs such as elections and in state employment without any special privilege or discrimination based on ground of religion, race, caste, sex, or place of birth. So as I said, that constitution and preamble main objective is to provide its citizens equality in terms of opportunity and status that they are having in the society. There may be no discrimination on any of these grounds which are mentioned in this, and there will be no special privilege to a certain group of people just because they belong to a higher status or they are wealthy. No special privilege will be there to a certain person or to a certain group of people, and there will be no discrimination in terms of opportunities that the citizens are getting. And even in the elections, as I said, in state affairs such as elections, no मतलब किसी भी एम्प्लॉयमेंट में जॉब अपॉर्चुनिटी हो या इलेक्शन हो, there should not be any discrimination of any sort. The word socialist was added by Constitution Amendment 1976, 42nd Amendment it was, and with that the term socialist was added in the preamble. This term is not defined. In general, it means a system under which means of production and distribution are state-owned. Socialist means where the production and distribution of the resources or the wealth is done by the state. मतलब state responsible होता है that how the resources or how the things will be produced and distributed among the citizens of the nation, like making roads, railways, all these are the work of the state, that is the government. And how to manage the resources, how will they distribute it, and all such things are under the face of the central government. And central government, or the state is what? Any organization or any institute in which 50% means half of the funding is from the government, half or more than half of the funding in monetary help is from the government, whether it is state government or central government, that all will come under state if the government is funding that institute. Supreme Court in case of S.R. Bommai versus Union of India held that principal aim of socialism is to eliminate inequality of income, status, standards of life, and to provide a decent standard of life to working people. So this is also a very landmark judgment and very famous case that is SR Bommai versus Union of India, in which it was held that socialism means that there is no inequality in terms of income. Means somebody is getting a huge amount of income because he belongs to this class or this strata of society. No, nothing like that. इनइक्वालिटी ऑफ इनकम नहीं होनी चाहिए. मेन और वुमेन को एक ही पोस्ट पर रहते हुए अलग अलग इनकम दी जा रही है. मेन को ज़्यादा, क्योंकि मेल डोमिनेटेड सोसाइटी है हम लोग कहते हैं, तो मेल को ज़्यादा इनकम दे रही है और उसी पोस्ट पे जो वुमेन एम्प्लॉयड है उसको कम इनकम दी जा रही है. तो ये इनइक्वालिटी है. तो socialism main aim is to eliminate this kind of inequality in terms of income or status, and to provide a decent standard of life, and to provide a 2 square meal to all the working people of the nation. Preamble establishes India as a secular state. We all know India is a secular state. Secular means no official religion. Each and every religion is considered to be equal, and every person has his own right to choose which religion he want to profess, practice, follow. India is a country of multifarious religions, means many religions, beliefs and sects. Its people profess and practice different religions, but India as a union of state has no official religion. There is no state recognized place of worship. State does not identify itself with or favor of any particular religion. State doesn't say, or any government will not say that I am a Hinduitva government or I am government only for the Muslims, because this nation is a Muslim nation. So you cannot see anybody saying this, because India is a secular state. Every religion is considered to be equal, on an equal status. State laws and policies prohibit any discrimination on grounds of religion. It treats all religions equally and confers protection to citizens to profess, propagate. Profess means उसको लेना, propagate to grow, प्रचार करके अपने religion को बढ़ावा देना, practice करना, उसको follow करना. The word secular was added by 42nd Amendment. So you see, 2 words were added by 42nd Amendment, socialist and secular. Remember this thing. 42nd Amendment of 1976, socialist and secular were added to the preamble. Even before the amendment, operation of concept of secularism was visible in the fundamental rights and directive principles. By birth of India was a secular nation, just that in 1976 it was officially also added in the constitution. This has also been given the status of basic structure in Keshwanand Bharti's case. We did in some of the previous lecture, I told you that basic structure should not be disturbed. So that case was Keshwanand Bharti case. Then we have fundamental rights, DPSP, and fundamental duties. Fundamental rights. Constitution guarantees its people certain basic human rights. Fundamental itself, this term means some basic. So fundamental right is what the Constitution gives its people some basic human rights to maintain the dignity and the value of, the कहते हैं ना human rights violation हो रहा है. So some basic human rights which are important for the survival and dignity of an individual, that all are provided to each and every citizen of the nation. And if any of the fundamental right provided is violated by any other individual, then the person can sue in the courts, and that is by writ jurisdiction of Article 32 and 226 of Supreme Court and High Court respectively, which are listed in Part 3. So fundamental rights are in Part 3 of Constitution. Remember, Part 3, Articles 12 to 35. These are broadly rights of equality. Now what these fundamental rights are, let's see. Rights of equality: equality before laws and prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Equality of opportunity in matters of public employment. Abolition of untouchability and titles. So पहले titles हुआ करते थे, राजा, महाराजा, है ना, कर्नल, ये सब titles अब हटा दिए गए हैं. There are no titles now. Untouchability is abolished by Article 17. and there is equality of opportunity in terms of elections or in terms of jobs which are provided to the people. There is no discrimination on any ground which are mentioned here: religion, race, caste, sex, place of birth. No discrimination of any sort is done. Equal and same laws are for everybody, and equality before law means everybody is treated before law. When you go in a court, a rich and a poor person, but the court doesn't see that you are rich, so I will give the verdict in your favor. That doesn't happen. Everybody is treated at same strata in the eyes of law. That is equality of law, and that's why that lady wears a black band over her eyes so that she may not see which person has come rich, poor, or whatsoever, and she may treat everybody equally. That's the way. Right to freedom: rights regarding freedom of speech, expression, free movement, form associations, practice any trade or occupation. So any person can follow any religion, can speak what he thinks of. He has freedom to think, he has freedom of speech and expression. He can express whatever he wants, he can speak it. That's why we have so much freedom that daily you see some of the other protests are going on, because we have the freedom to do that. We have the freedom to form associations and to speak what we want. If we are thinking that this policy of government is not correct and we need to quash it, so we can form an association and we can speak, because we have freedom to do these two things. We have freedom to speak what we want, we have freedom to form associations, and then we can protest. And any person can follow any trade, any occupation, any job he can take up. Protection in respect to conviction for offences, protection of life and personal liberty against arrest and detention in certain cases. So in certain cases against arrest और डिटेंशन मतलब प्रिजन में बंद होने के लिए भी प्रोटेक्शन दी जाती है. लाइफ एंड लिबर्टी, फ्रीडम होता है, protection of life because there is some privacy which is to be maintained, and to protect the life nobody can kill you so easily, so that sort of protection is provided. Right against exploitation, we say this basically in the terms of child labor. You cannot sell any human, that is selling of human beings is also done, right? So you can't sell any person. That will also come under protection of life and under right against exploitation. Child labor is also under this. Right to freedom of religion, everybody knows what it is. Cultural educational rights means 6 to 14 years gap, every child is entitled to get education, and that is Right to Education Act was also passed for this. So right to education and constitutional remedies, that is what writ jurisdiction were. The right to education was inserted as Article 21A, White, the Constitution 86th Amendment Act 2002. Fundamental rights stated under Article 14 and 21 are even conferred to non-citizens, means who are not the native citizens of India. They may also be granted some fundamental rights which are under Article 14 and 21. Now you will find out what these two articles say, 14 and 21. And please remember, right to education was added in the year 2002 by 86th Amendment, and it is under Article 21A. So you need to remember this much. Right to property was originally a fundamental right. Okay, so ये भी बहुत इंटरेस्टिंग चीज़ है. जहाँ पर ये कैपिटल ए लिखा होता है ना, ये 21A हुआ या ये 300A हुआ, so wherever this capital A is written, that means this is inserted by an amendment. ठीक है, like 21A, so it was inserted by 86th Amendment, 300A 44th Amendment. So wherever this capital A comes, that means it is inserted by an amendment. So right to property was a fundamental right, but after 44th Amendment it was removed as a fundamental right, and instead of being a fundamental right, it became only a legal right. So, stating that no person can be deprived of his property saved by law. That's why it's illegal right now, and it is in Article 300A, and it was by 44th Amendment. So, which article, which amendment, which year? These three things you have to remember. And what was the interesting story behind this thing? Actually, when India got it independent, major of the land gone to Pakistan, and the people who came here from Pakistan, they were having no land where to live, where to cultivate the crops, or such problems was there in front of the people. So to manage that, पहले right to property fundamental right थी. So each person was fundamental right का मतलब है कि हर बंदे के पास उसकी एक ज़मीन होनी ही चाहिए. तो ये चीज़ बहुत गड़बड़ करी थी, बिकॉज इंडिया वॉज नॉट सो प्रॉस्परस एट दैट टाइम व्हेन पार्टीशन वॉज डन. अराउंड 50 crores were to be given to Pakistan. So it is a huge amount. It's still a huge amount at that time, 1947. That was a huge monetary amount. So to manage that and to provide land to everybody was a very hectic task for the government of India at that point of time. So they decided that they will remove right to property from the umbrella of fundamental rights. So that's why it was taken away, and then it was put in the category of legal right. The fundamental rights guarantee to the people certain basic rights. Legislative and executive actions which infringe upon or violate the fundamental rights are declared ultra vires the Constitution. Ultra vires means outside. So any fundamental right, any law which is framed by the Parliament, if it is seen to violate any of the fundamental right as mentioned in the Indian Constitution, then that law will be declared null and void by the court. Okay, because basic structure need not to be disturbed. Basic structure of the Constitution should not be disturbed, and fundamental rights are the basic structure of Constitution. That's why any legislation or law, if it violates any of the principles of fundamental rights, then that law will be declared null and void by the courts. Supreme Court shall have power to issue directions, orders, writs, including writs in nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, whichever may be appropriate for enforcement of fundamental rights under Article 32, and High Courts under Article 226. So I told you these five are the writs, and these can be issued by Supreme Court under Article 32 and by High Courts under Article 226. All these five writs we have done, I guess. The speedy and effective remedy under Article 32 is itself guaranteed as a fundamental right. So the Article 32 constitutional remedy is itself a fundamental right. Therefore, these guaranteed rights are termed justificable rights. Means these can be taken up to a judiciary. That's why justiciable rights, and these are also fundamental rights. So next turn I will start from deductive principles.